questions and make sure that at the end of it that we can go through those questions and answers that is given. So if you don't want your picture to be on the Zoom, you can just keep the camera off and that will be fine. We'll just work on audio. Thanks for that. So people already identify where they're calling in from different part of the country. Can I just ask Roland, can you just introduce yourself, Roland, as to what part of the country you're located? Are you there, Roland? Okay, so Roland may have stepped away from the computer. So Roland is located in the northwest, sorry, in London, in Middlesex. So welcome to our question. Just a couple of points before we begin. We had a conversation, Tanika and myself, and we feel it would be more appropriate if we have the question at least 48 hours ahead of our session. It will allow us to have time to research the answers and to have those conversations to arrive at the right answer. If the questions are very much very short time span, it may not be possible for us to give you the answers because we may need to go out and find additional information to support your question. So we will be updating the Eventbrite information that all questions to be submitted at least 36 to 48 hours ahead of the session. And that will give us ample time to look at the question and do some research to give you the right answers. And if we're still unable to give you the answers, we will then find the answers from our professional legal network. So I hope that will help. If we're not able to answer all your questions today, maybe because of short notice, but we will do the best we can to answer your question. These sessions are important because they are the question that you as individual want to know. And that's the whole purpose of these conversations. Our Sunday chat is very much focused on a different format, which is really giving you information regarding who's eligible to apply for the scheme, and then breaking down into individual section of the compensation scheme. That's a different platform. But also just to say that Justice for Windrush Generations is supporting law with these sessions, and law will be supporting Justice for Windrush Generation as we go forward. We're working together on these issues. And so we hope that, by bringing the two organizations together, we are able to increase our capacity and a better support for everyone. So that's a little bit about the purpose of what we're here to do. And one or two questions came in to us, but there's also the opportunity to raise the question as you feel fit now on this platform between now and 5 o'clock. And if the questions are, if we're not able to give you the full answer, then we will return with the answer as we research that information. So I hope that is helpful just to set the scene. Please tell other people about what we're doing. It's important that we communicate about Windrush. It's important that we tell friends and family about Windrush. and there is organization out there that can help. I was over in North Wales yesterday, and the people I spoke to, predominantly from the African community, of very little knowledge around Windrush. And so we continue to reach out to Pacific communities, Africans, Asian, across South Asia. There's a lack of understanding about Windrush, whether they are part of Windrush. They see Windrush as a Black Caribbean, and in particular, a Jamaican issue. And that's because of the narrative that we've seen by the BBC when they talk about Windrush people arriving in 1948. All they focus on is 500 Jamaicans, not the 1,027 other passengers on the ship. So you can understand why people ignorance about Windrush is there. The narrative, it's out there. We're trying to break through those inaccuracy and that narrative and try to correct it. So these sessions help to challenge those issues, and we want you to help us by taking the information out into your community, into your families, into your friends, so that they will know that Windrush is a global issue. It's not just for Caribbean people, and there are over 20 odd Caribbean islands. The last count, I think, was 23, either 23 or 25 Caribbean islands. So we've got the Caribbean, and then we have the rest of the world. So we have what we call the former Commonwealth countries, and there are lots of those. So when we talk about Windrush, we're talking about a global issue affecting people from across the globe, from across the Commonwealth. Caribbean is only a small part of the Commonwealth. So let's reach out to our African brothers and sisters and our Asian friends as well. Okay, so that's a little background about Windrush. Just to give you the context, and it's worth mentioning that the period that we refer to as Windrush runs from 1948 up to 1989. That's the period that is the Windrush generations and descendants. That's the period. We've also mentioned that it doesn't matter what mode of transport you arrive in the UK, doesn't matter whether you came on a ship or a plane or by any other means. What's important is the timeline, the date, 1948 to 1989. That is the period. Mode of transport is of no importance, just the relevant date. And we emphasize this because if you arrive in the UK after 1989, for example, 1995, then the Windrush scheme doesn't apply to you. You're outside the Windrush scheme. And if you have information relating to dates after 89, that would be an inquiry on immigration issue. So we focus on the compensation timeline, but we do have someone who can assist with immigration query. We're not suggesting that, that's going to be our focus, but we have someone who can assist with immigration query. So if your question fall outside of Windrush, outside 1989, and you have a question relating to something a little later, then that question can also be answered. And if the immigration person not able to give you a definitive answer, then she will check it out and come back to you with up-to-date information. So I hope that is helpful. So we will focus on Windrush question as far as we can, but understand that there may well be borderline question as we go through. So the idea is that you submit a question and we will do our best to answer that question. So we have advocates on the call, and the advocates who are dealing with cases, with their experience of dealing with a diverse range of cases, they might be able to answer your question. So we'll see how we go. Okay. We've said this before, that the information we provide is free of charge, and all the support that we offer across law around the advocacy, there will be no charge. So make that quite clear. And when you speak to your friends and family members, please tell them the same. The support that we offer will be no charge. So, Tanika, let me
Yes,
come to
Gareth.
you
Thank you.
first. So
Yes.
let's just begin our question. How many questions have we received in the last 2 or 3 days?
So we've received two from two persons. At least Roland forwarded me two
Okay.
that came through. The first one was on the person reads, and I'm as I just mentioned to somebody in the chat, I'll try to be general to not give away personal identifying markers to anybody's specific cases, but
Yeah.
also we'll still try to answer the question the person asked. So this question relates to returning residents. And the person made an application. They sent off their passport with said application, but because of a death, they had to ask for the passport to be returned so that they can travel from the UK to where the person died. So the
Mhm.
person who died had applied for the returning residence visa, but subsequently died. Okay. If I'm reading this correctly.
And so, what is the
One,
what is
okay,
the
I'll just
question?
read it
Yeah.
because you might have a different interpretation. My apologies. So after submitting a returning resident application for my mother, her mother passed away and she had to go back home in an emergency. The Home Office said that her application would be classified withdrawn if they had to return her passport. What should have happened? Did they act correctly? That's the question. And the
Right.
scenario was what I read before.
Okay. So the question is, as the Home Office applied fairly, um, you know, um,
Acted correctly by
acted correctly? Yeah.
saying to the person that should we return your passport to you for you to go home in this emergency,
Yeah.
that you would lose your return, the application effectively will be withdrawn. So my
Yeah.
answer to that was, and I think I sent a message back to Roland, was that was that it depends on the situation. Um, you could, because a debt is an extenuating circumstance, Garrick.
Yeah.
Um, you could get your passport back, or they can give you a travel document, from my knowledge, for you to travel. So you may not have needed your passport, but they could say, well, okay, in this case, you still want your application to proceed. We could give you an emergency travel document, and then you can come back if that's the case,
Hmm.
because it's a debt. However, we need further information in order to help that person. So when they traveled, did they stay over there for a month, a
Hmm.
year, 2 years? or did they come back? So the question is, when did they return to the
Yeah,
UK? Did they return at all?
yeah, yeah.
Or what
That, that
happened to the
that's quite
patient?
important. The actual timeline is important.
Yeah,
Being away from the UK, we need to establish, how long the person has been away from the UK, in order to because there is legislation that state clearly that being out of the UK for a specific period of time, um, which is 2 years,
yes,
then 2 years and one day, you then lose the right for re-entry.
yes. Your status would have lapsed
Yes,
effectively.
yeah.
So that
However,
person, mhm,
however, if there are mitigating circumstances, that's the word we should be using. A
yes,
death, for example, is a mitigating circumstance that apply to anybody in emergency, then we can challenge that on that basis. I guess the next step would be, and we don't know the time. We don't know the time of this situation when it happened. If it's recent or it's 10 years ago or whatever, we don't know that. That hasn't been established, has it?
no, it has not. So that all what I read was what I received,
Yeah.
and unfortunately, that's not a lot of information for us to go on.
No.
But just
No.
to answer in a general aspect, then we will need more information.
Yes.
Because
Yes.
if you, for example, decided to go and you stayed on there because the funeral arrangements took longer than 2 weeks,
Yes.
had you, as you had imagined, or you had difficulty returning after a month or 2 months, then you may fall on the scheme depending on when it is or when it was. But
Yeah.
without us knowing everything or the details surrounding that, and that's what I
Yeah.
mean by everything, we can't really
No.
accurately
No.
advise you.
No. So what we're asking, in this case, is for more information relating to the situation and the circumstance surrounding that. And if we get more information, we're able to look deeper into the case. The rule will stay the same. 2 years and one day will apply to anyone out of the UK. Um, but again, as I said, we don't know all the facts at this stage. So I don't think we can say any more on this one
No,
uh,
we cannot,
until we gather
unfortunately.
more information.
Correct. And the next person that messaged then, they had three questions. And the first question from that person is, can successful overseas Windrush claimants apply for UK citizenship in the same aspects of Vanrel and Toomey without having the 5-year residency rule? I'm not sure what Vanrel and Toomey are, and I'm not sure if I'm supposed to know what it is. So if the person is online and they would like to come on mic and give further insight into Vanrel and Toomey, I'd appreciate that personally. This
I've read
message
that
was,
question myself. I have read the question. The person is here on the call.
yes, but I don't
I
want
don't
to
I don't
identify the
know I don't
person.
know that example.
Neither
Um,
do I.
no,
But what I
but
will say, sorry for cutting you, Garrick. What I will say abstractly, the person doesn't have to feel pressure to come online to
no,
speak. What we will do is answer to the parts that we can. And also
yeah,
because this message was received at short notice or not with enough time for us to research who
yeah,
Van Rel and Toomey are, maybe they may be cases, because the second question relates to a case that I am aware of, the Mahabir case from Trinidad.
yeah.
Um, so we can come back with full answers either via text or on the next platform. But for the first question, I'll read again. Can successful overseas Windrush claimants apply for UK citizenship in the same aspect of Van Rel and Toomey without having the 5-year residency rule?
Mhm,
Um, Thank
Interesting.
you. Thank you for sending me that information. I will read it when we're off the call, or maybe whilst we're answering another question. The person just sent me the link to the case. So thank you very much for that. My
Okay.
father lived in the UK from 1964 until 1984. And with regards to that question, I have some information for you as an answer. So I shared a link in the chat, which gives full eligibility details and guidance with regards to the scheme. So if the person could refer to that as Windrush scheme full eligibility details, and on there it's under the subheading a person outside the UK. It reads, a Commonwealth citizen who was settled in the UK before 1st of January, 1973, but who does not have a document confirming their right of abode or settled status, or whose settled status has lapsed because they left the UK for a period of more than 2 years. That's a person outside of the UK. And to answer the person's specific question, it says, if so, and the applicant states on the application that they want to return to the UK permanently, they will be granted a returning resident visa, which this person's father has happened. And the question is, do they have to wait the full 5 years? Their guidance, the Home Office guidance here says, on returning to the UK, a returning resident can apply to naturalize as a British citizen only after they have been resident in the UK for a further 5 years.
Yeah.
3 years if they are the spouse or civil partner of a British citizen. They will not have to attend a citizenship ceremony unless they want to. So, based on their policy here that I've just read, the answer to that question, the first question is no, they would not be able to get it without being here and having a right to be here, right of abode for 4 to 5 years after getting their returning resident visa, unless they have a spouse who's British or a civil partner. They can get it in 3 years. So that's the first question from the person, Garrett.
Yeah. Just pause there because there's an additional point to be added. If the person is an ex-military person, then they would not have to go through what Tanika's just mentioned to wait for that period of time, 3 to 5 years. However, there is this point, and must emphasize, residency. So the person who the eligibility criteria is exactly the same. You must have been settled. You arrive by 1973 and you're settled in the UK, settled. And then you leave the UK to go out and come back. You were settled. Okay. Now, this issue, what Tanika has just picked up, the person may have gone out of the UK for 4 or 5 years, which meant that they've been away from the UK for a period of time. She just mentioned what the rules state in getting your citizenship and how long it will take to get your citizenship. And we're talking about a 3-year period or a 5-year period, and the 3-year period is in relation to a person who already have a citizenship in the UK, spouse, so whatever. But the 5-year, there is no shortcut to the 5-year. That's how I read the guidance. There's no shortcut at all. You know, it has to be that period. Is that how you understand that, Tanika?
No, it's not. And the reason why I say that there is a shortcut if you have a spouse who is already British.
Yes.
Or
that's the exception.
Yes, and that's the only shortcut. There is no
Right.
other. The
Yes,
spouse
yeah,
has to be British,
yeah.
a civil
That's what I
partner.
meant. That's correct. Yeah.
My
That's the
apologies. Sorry.
exception. Yeah. Yeah. So if you've got a spouse, so that's the only way. Otherwise, you will have to wait for the full period of 5 years.
Yes, that's correct.
Yeah. Is there anything more in that particular case that would there is no the family is not part of armed forces who have served in the armed forces, because
I'm
there's
not sure.
an exceptional rule for them.
I'm not sure. Well, we'll need to look at the forces covenant to determine that, because I'm a British veteran. I'm ex-army. I've done over 12 years in the British Army. and there are specific rules. So serving members of the armed forces, be the Air Force, the Navy, or the Army,
Yes.
and veterans and their families. Without a specific question being posed, we can't really ascertain what the covenant states. But we're happy to do the research and get back to you. And maybe in ex-military, I do have some knowledge around that. So unfortunately, Garrick, I can't really answer that question
Okay.
without having specific details to compare what the legislation states.
Okay. That's all right. Roland, I'm just going to ask you also in relation to ex-military. Is there anything else that we need to identify in relation to a person returning to the UK? We already explained the only way, the exception to the rule, exception to the 5 year. Is there anything else that we need to say? Are you there, Roland? Okay, so I'm not picking up anything. Let me just read a couple of paragraphs from guidance. Windrush compensation scheme. Individual who live abroad, are they able to submit a claim? And the answer is yes. You can apply from overseas if you're either Commonwealth citizen who settled in the UK before the 1st of January 1973, or you're representing the estate of a deceased person, a close family member of an eligible individual who is evidence of certain direct financial loss or significant impact to life. And then is another paragraph says, do overseas claimant need to have a lawful status in the UK? Commonwealth citizen who settled in the UK before the 1st of January 1973 are now overseas, do not need to have lawful status in the UK. They just need to prove evidence that they are settled in the UK before the 1st of January 1973. So, Tanika, just say about the evidence. They just need to provide evidence that they were settled in the UK before the 1st of January 1973.
Yes, thank you for that, Garrett. No, settled status and the evidential burden that the Home Office is asking for is really, really high. I say that to say that that brings us into a whole different conversation. And that conversation is, first of all, to understand both Windrush and the hostile environment. Because I use this quote because she's a prominent person in society. She's the ex-Prime Minister, Theresa May. In her memoir, which was released a few weeks ago, she said that the hostile environment started in 2007. Not 1948 to the 1st of January 1989, 2007. And the reason being due to successive legislation that discriminated against the people who came to the UK from the Commonwealth, i.e., the Windrush generation between 1948, on which is known as on the Windrush ship, hence the Windrush term, the Windrush generation, to the 1st of January 1989. I say that to say that how the Home Office, according to one of the advisors that we've spoken to, the Home Office is independent advisor on the schemes. My apology, I was just reading messages as they came through in the chat. How she explained it is that, sorry, how the Home Office are looking at it is that from 2007 onwards, legislation that came into force, if people from that era are affected by said legislation, then they have more of a claim or likelihood of a claim, i.e., they can evidence things more easily because the paperwork will be existent or in existence. It will be maybe 10, 15 years, which paperwork I've kept for that period of time. But going back to 75 years ago, the evidence is just not there. Certain organizations may hold evidence, such as HMRC and NHS, for 100 years or even 200 years, I was made to believe. However, the Home Office themselves do not hold records past 1985. That's what they told me directly via email. So the Home Office do not have information going back past 1985, but became prior to 1985. And everything that we have to do in order to support any application, you have to provide evidence, as Garrick said. So the question is, where do you get evidence from to support your claim, especially if you came in 1973 or prior or after? It's a difficult one, but some people may have evidence showing that they went to school here. The schools may still be in existence. They may have converted their paper documents to electronic, so they may be able to retrieve some things. Your previous employer, they may have something. You just have to ask, maybe the local councils, the housing schemes, or the people, they may have something, but it's really difficult to find evidence after a certain period of time, which is one of the things that we're making people aware of, so you know what may be a challenge or a barrier. However, it's not impossible, and we're here to help you. I don't want to go further on because we have other questions I may link into that again, Garrick. So I hand
That's
back to
fine.
you.
No, that's fine. Thank you for that. Just a bit of additional information regarding evidence. So Tanika mentioned a couple of things, mentioned school, for example. School may no longer exist, but information from HMRC, if you have worked and taxes been collected, then that's another means of evidence. And their record goes much further than the Home Office timeline. Yes.
Garrick, before we continue, Roland would like to speak. He has
Yes,
his
I'm going to
hand
bring
up.
Roland in now. Yes, sorry, son. Roland, can I bring you in now, please? Roland, can you hear me?
Also, we have just gonna check. There was somebody else's hands up. Simpson Thompson, R. Simpson Thompson also
Oh,
had their
sorry.
hand up.
Yeah. That's me, Rafa. Sorry.
Okay.
Yes.
We'll take your question. I'll come back to Roland. Yeah.
Right. So mine was just a comment. So I did read briefly about the Van Rail case. It was about a boxer. So he won in the High Court, I think in 2021, which stated that the Home Secretary does not have to abide by the 5-year rule. And in fact, because basically his argument, I think if I'm remembering correctly, was that it was the Home Office that prevented him from being in the country to apply for the naturalization. And so he won. And so now the Home Office's argument was that they had no choice but to abide by the 5-year rule, and there was no discretion in that regard. But now the ruling is that they do have a discretion in that regard. So if I'm remembering correctly, that was what that case was about. So even though I know the link says, I don't know if that's the latest position, so I'm not sure. But if I'm remembering correctly, that was what that case was about, and he did win.
Okay. Thanks for that. So the thing is, where case law is important, and if you have a ruling on a particular case, then of course, then that can be used as a precedent for other cases. Any comment on that case law, Tanika?
Yes, and Raffer, I think that was Raffer, if it or whomever.
Yes, it was me. Yeah.
Okay, thank you. That is something very important that you said. There is a discretionary element that the Home Office or the Home Secretary can apply. Now, that is something that's given to her through legislation, and she can apply it however she chooses. Whether she says, "Well, we're not going to waive the 5-year rule," or we're going to, and that's for the courts to interpret, because that's what the court's job, to determine what Parliament meant when the legislation was created. Now, case law is very important for us as advocates because we can use case law to argue or advocate in our applications that here the court held that you should have acted this way, and based on that, we're asking you to to apply that discretion in this specific case that we're applying for to get a person the remedy that they're seeking. So that's very important. I was not aware of the case until now, and somebody was kind enough to put it and send it to me. So I will have a read of it. And please do feel free to send me more on cases and things that come through, because I would not know everything. I do not know everything. So if you guys help us, we can better help you. So thank you for that.
Excellent. Thanks for
Sure,
that,
no problem.
Tanika. Roland, are you there? Can I bring you in now before I move on? Can you hear me, Roland? I'm just wondering if he's having audio issues. Okay.
I'm not sure because he was messaging in the chat
Yeah.
before, but we'll come back to that. I can read the next question that was sent in.
No, just before you move on to the next question, Tanika, I just want to make an additional point from where you just left off with the
Yes.
case law. The new Immigration and Borders Bill does have within it, Home Secretary have discretion. That's also written in the new piece of legislation. It's not been tested as yet in the courts, but it's actually there in the legislation.
In addition to that, Garrick, it just reminded me that we have strategic partner with a law firm.
Yeah.
That if we do receive cases and we think, well, the Home Office has the discretionary power to apply here, and they should, and they haven't, and they rejected the claim at the initial stage, then tier 1 and 2, we have someone who's happy to take your case on free, basically. They'll apply for legal aid on your behalf and take the Home Office to court. Because going back to precedents and case law, the more that we have, or the more that is created, which means you will have to go through a bit long of a journey, but it'll still help others to come in and also help you. Because if we can get a course to rule on, Roland says he cannot unmute. We will work on that in a second,
Let me
Roland.
just have a look. Yeah.
Okay. If we can get the court to rule on actions or lack thereof of the Home Office, that will be better for us moving forward, because hopefully then we can get claimants the desired results. So we do have someone that's willing to apply for legal aid on your behalf and to take the matter to court, which may even lead to a judicial review, which is essentially what it may go through as, because it would mean that the Home Office failed to exercise one of its powers granted to them under legislation.
Yeah, that's good. I cannot unmute Roland. You can do that, Tanika.
Yes, I'm going to try that.
Yeah, I haven't got the full host.
Okay.
While bringing in Roland has mentioned in the chat about the hostile environment. This continued to be an issue as to date, and although we've established from what Tanika said with the former Home Secretary Theresa May, hostile environment and the legislation being roughed up, as it were, ramped up. Many people feel that the hostile environment start well before that period, and that's fine. There's no issue with that. The only thing that we would say about this, when you're looking for evidence, and back to what Tanika said, when we're looking for evidence, we have to. It's the duty. We're the individual have to find the evidence to support our claim. And so if we're going back 20, 30 years and we haven't got any evidence to support that, it means that we won't be able to go back to that period. And it is clear that the Home Office is now focusing on restricting that period. In other words, they don't want you to go back as far back as you would like to. And so, this continue to be an issue. When we met with the independent advisor around this issue around hostile environment and trying to find evidence And this is always the issue, finding the evidence to support our claim, how we've been impacted over a long period of time, whatever long period of time it is. There is, not many places that we can go to get or to find the evidence. It may be, and we said this before, where you've worked, the factory no longer exists, and you cannot get that information. But one of the sure places that you can find information would be HMRC, because tax have been collected over a period of time, tax, national insurance. So that is a sure place where we can find evidence. If you're trying to find evidence relating to former employer, and other people who were working in the factory, when you were in the factory, if 3 or 4 people can produce a statement that they work for this place in Birmingham on this period of time, that may well be considered. But individual trying to find on their own and not find information, it make the claim really difficult, and you may not be able to substantiate your claim for that period of time. So it's really what we're able to prove, what evidence we're able to provide. And we have noticed that evidence is being shortened in the way that the Home Office is actually looking at the case. And there was one particular point that was mentioned. I don't think people understand that if you've been impacted for 40 years, you will not get 40 years of compensation from the Home Office, if you're thinking that way. And we've had this conversation. I'm just going to bring Roland in a moment, but Tanika, in your experience of dealing with cases, what's the furthest number of years that a case has been awarded?
From my knowledge, the cases I've dealt with haven't had that award for a number of years, but I wouldn't think you go back more than 10, 15 from the things that I've heard from other people, because people who have been affected from, I know people who are affected from 1980s, and then we're in 2023, they did not award them for that period of time.
Yeah.
So they've only went back again, going back to somebody just, maybe when Roland come online, he can speak for himself, but said that the Home Office narrative of 2007 is not when the hostile environment started. And I agree with you, Roland. However, I say that because that's what they're applying, even though we may know different, feel different, or any whatever different you want to put, adjective you want to put in front of that different, that's when they're applying the cases when they get it. So we need to know what is happening in order to know how we can do something about it, or at least manage people's expectations in the least. So no, you're not. And you said it, you were accurate, Garrick. You were right. They're not going to give you 40 years if you've been affected for 40 years. It's not a restitution scheme. It's a compensation scheme. And they only awarding you for significant loss as a result of your inability to evidence that you had a lawful right to be in the UK. It's they said on the balance of probability is a standard of proof. That's really high, bearing in mind what they want from you and keep asking from you. Bearing in mind, they know that they themselves don't have records to substantiate one way or another to some degree, much less how much you. How many of us in today's society go to the shop last week and still have the receipt this week? Just a receipt from your shopping, much less more important documents from 75 years ago, 50 years ago. So
we have to be realistic, and we need to say this because people may be thinking that I've suffered for 30 years, 40 years, I can be compensated. You will not be compensated for that period of time. And just be realistic. The Home Office has narrowed the claim down to a specific period, and I don't think they will change that at all. unless in the future, if the claim is somewhere else, it's on an independent basis. But at the moment, that's the position. So be realistic in your expectation when you submit a claim, that you will not be able to be compensated for X amount of years, even though, and I keep emphasizing this, even though you have suffered, and there's no dispute of that, you have suffered, but you will not get the claim for that period. Let me
Garrick, I
just,
would like to take a moment and recognize a dear colleague of mine, Mr. Young. I
yes,
don't know if you'd like to come on mic and say a few words. If not, I respect that. I
sure.
am calling on him. If he wants to give out his credentials, please feel free to do so. I think he's somebody that, people on here should know about, should meet, and who
Okay.
may be able to help other people calling in, because there are people calling in from London.
Yeah.
So if you feel free, Mr. Young, and you're happy, please continue. If not, we will continue with the program. But thank you very much
No
for
problem.
attending.
Thank you for the invitation. I don't think I'd want to come on screen now.
No,
I'm
not
sort of
screen, but
multitasking.
voice.
You don't want to come and
And-
scream. No,
and-
if you like to say anything, then that's okay.
Well, the only thing I'd like to say at this moment in time is well done to all of you. I mean, I listened to the legal arguments, and it's absolutely brilliant the way that we've got people in our community who are applying themselves to this. My own background is actually from the Home Office. I worked there following the Steve Lawrence inquiry. I went there as the first black senior civil servant working there. I worked with Jack Straw to amend the Race Relations Act, and including the public sector duty to promote equality. And so I know the way that Home Office works. I know that they don't have our people's interest at heart. Who's surprised by the hostile environment? Certainly not me. I was really up against it in trying to amend the Race Relations Act. So we just have to keep our shoulder to the wheel. And I'll say I'm actually making notes here about it's not a restitution scheme, and they won't go back further than 2007. This is news to me. I hadn't realised this, so I'm learning as well. I will be running programs out of my charity in Croydon. It's called Croydon African Caribbean Family Organisation. So we'll be having surgeries in the period up to Christmas. I can give you the dates if I can find them to hand.
Yeah, no, that'd be helpful. Yeah.
Yeah.
You can put that in the chat for us. That'd be helpful. Yeah.
Yeah, I will do. I mean, we're going to have meetings there on between 7 p.m. and 9 p.m. on Tuesday, 31st of October, 14th of November, 28th of November, and 12th of December. And I will post a flyer in the chat so everyone's aware of it, because it's absolutely important that we raise the awareness, but also don't give people false hope.
Yeah.
You've got to be absolutely crystal clear what's on offer here. And I like the way you just expressed it.
Yeah.
Thank you ever so much.
Thank you very much for that, Carlton. And it is
before you continue, Carlton is a counsellor.
Yes.
And I don't know if a lot of people know what a counsellor is in the UK, but Carlton, if you don't mind, you give them a little background. It's just the reason why I want people to know about you is that they have somebody in the community they can turn to for help other than us. And it's about making that available. I'm really keen on that. Thank you for coming on camera, Carlton, so people can put a face to the name. But this is important to have people in certain positions. We don't have enough access to people. And why? Why should it be like that? So I'm really trying to break down the fences and barriers. Thank you very much, Carlton. I'll hand over to you.
No, I very much agree. I'm a councillor in Croydon, which is the largest borough in London. I'm a councillor, and also, interestingly, Croydon has more Windrushers than any other borough in London. I just found out last week, looking at the census data, that Jamaicans, for example, are the third largest ethnic group in Croydon.
Wow.
And certainly in my ward, we have lots of Windrushers. And so I spent yesterday walking up and down our high street, putting up flyers to advertise these events that I'm having at my charity, starting this month, because it's worrying that so many people aren't coming forward. We know that £200 million of compensation was announced when the scheme was launched back in 2019, and only about 60 million of that has been paid out. So clearly there's a gap between the expectation and what's being delivered. And I think working together, certainly with Action for Racial Equality and others, we've got to try and close that gap as much as possible. So thank you very much, Tanika. Here I am in my little glad rags.
Oh, no, that's really good. And I've learned something. I did not know Croydon has the largest Jamaican population, because I'm from Brixton, South London. I grew up on the front line, so I thought Brixton was the place. Lambeth was the place. So I didn't know that Croydon has got a larger community.
Can I briefly retort to that? I
Yeah.
was born in Lambeth. I was born at
Yeah.
Brixton Hill. And
Yes.
I know that front line. But
Yes.
Lambeth is now gentrified.
Yes,
And
of course.
most of us who lived in Lambeth have now moved to Croydon.
Oh, yeah. Well, interesting enough, when I was in London, people were already moving out to Taunton Heath, coming out of London and going into Taunton Heath and other places. So yeah, it has changed. Yeah, absolutely right. But it's good to know.
Can I make one more point? It's just come to my mind. You see, I spoke about gentrification, and this is part of the hostile environment. All of that is part of it in my mind. We got gentrified out of Lambeth. And what I discovered when I became a counsellor, this is the reason I became a counsellor in Croydon, they banned Jamaican music in clubs, like Sean Paul. We called it the ban on bashment, but it was much wider. And I did a review. I'm serious. I did a review of the ban, and it turned out it was written into licensing policy that there is a presumption against licensed events in Croydon where you have DJs and MCs who talk over recorded amplified music. But that's most reggae. It's all hip hop. It's all grime. And the ban was in place for 10 years. So as a counsellor, I got the council to publicly apologise last week for that 10-year ban.
Excellent.
So I'm quite chuffed about that.
That's brilliant. That's brilliant. You're doing wonderful work. So in Croydon, are you South Croydon, are you West Croydon, or are you East Croydon in terms of your constituency?
My constituency is in north of the borough, Thornton Heath.
Yes, I know the area. Yes, yeah.
Okay, well, thank you very much for that.
Really nice for you to come on and contribute to this discussion. Thanks very much.
You're welcome. You're welcome.
Yes, and I will ask you for a copy of the statistics, Carlton, with the different demographics on areas of where Windrush affected.
Happy to do that.
Thank you very much.
Brilliant.
All right, all the best.
Yeah, Roland, can I bring you in now, because I think you've been on mute? Correct? Is that correct? You can speak now. Okay. All right, Tanika, can we take another question, please?
Yes. So this is a follow-up to the first question, which related to Van Riel and Toomey. The second question is, what about husbands or wives of successful Windrush claimants? What are the routes for their entry to the UK? Is the fee waived, like in the case of Mahiber, Trinidad? That's the second question. So Mahiber Trinidad, for people who may not know, and the little that I do know of Mahiber, is the woman who had left the UK, I think maybe 40 or 30 something years, and came back with her husband and 5 children once the matter went to court.
Yeah.
And she was able to return with her family. So as far as I'm aware, with case law, yes, that is a case, because that's a perfect case.
Yeah.
And that is there. However, my understanding generally for returning residents with families is if they've been living under the same roof for 2 years as a returning resident, and if they're under the age of 18. But without having specifics, I will have to get back to you. Also, something to consider as a returning resident, you have to demonstrate as part of that eligibility that you have close and continuing ties in the UK. Yep. You just, as much as you may want to return, you just would not be allowed to return unless you can establish that the UK will be your home, is your home, and you had not been out of the UK that long that you've made some other country your residence or your home.
Yeah, that's a good point. It's a good point. And it's good for people to understand. We've highlighted a couple of case law cases, and they're very, very useful to know because case law does give us the precedent in terms of, our case might compare with that case. So I think that's important for us to continue doing so, because a lot of people don't understand case law. So when we bring these cases to these platform and in these conversations, it does help individual to get a sense of how it can be applied to their case, to their situation. So case law is not just an isolated thing. You need to look at the case. You need to see in that case what judgment came out of that case, and then look at your own case situation and see how your case may well compare with that case. That's important, and we continue to look for new case law, and this is what our external partners are interested in. They're looking to find ways of challenging the Home Office, challenging the government with cases. Sometimes they're not successful because they do so much, and the judge have said they couldn't go any further. But we need to keep doing that, because that's another way that we can actually get a result that will benefit a wider audience, not just ourselves, but a wider audience. Let me just read something to you from the guidance. What assistance is available to those applying from overseas? The Windrush L.A.W team can assist you should you have question about the claim form or process, or need help in assessing claim and guidance. Refer to your claimant assistant provider, and that is We Are Digital. We Are Digital, who can provide free independent assistance with completing the claim form. We Are Digital can help to listen to your experience, advise on which category of your claim you might be entitled to, and how to gather appropriate supporting evidence and documents. Provide language service where English is not your first language. I pause there. I'm going to bring Tanika in to comment on this in relation to We Are Digital. I
stutter, and I'm hesitant to comment on the organization We Are Digital.
Yeah.
But what I will say, it's what's known to be factual knowledge, is that they were the organization commissioned by the Home Office to support Windrush claimants or people who wish to apply to either of the Windrush schemes. Unfortunately,
they still have the contract. Yeah, they still have the contract.
Yes. Unfortunately, the cases that we've received from them, or the referrals they've made to groups like ourselves who were unsuccessful in getting the same contract from the Home Office, they are not fit for purpose. And that's from my personal experience. So I'm very wary with regards to slandering said organization. And I'm not doing so. I'm merely speaking from personal experience with cases that have come to me and the organizations I've been involved with from them. We offer, somebody asked in the chat, how can they get help with their applications and stuff? We offer help with, first of all, understanding the application. You cannot understand it. If you don't understand it, you can't fill it out properly. And we help you to understand, as we're doing here, the limitations and barriers that you may face, but also give you solutions. So we're not going to point out a problem and not try to help you fix it. We help you if you just want, for example, have a question, you're not sure, we'll try to find the answers for you. That's what we're here for. We're a community organization, a constituted group, and we're here to help, free of cost, free of charge. We want to, my personal aim, I'll speak for myself and Gareth can speak for himself. I would like to help people to be in a better position than they were The scheme is an opportunity that could either really make a significant difference in your life by compensating you for some of the wrongs that have fell on you from the Home Office or from the government or successive governments. Either way, if I can help, I will. I am training to be a barrister. I'm not qualified as yet. I work with solicitors and I have a great degree of legal knowledge. I can interpret and apply cases to the application as an advocate. So please do keep sharing cases with me. I do not know everything. I reiterate, I do not know everything. I am willing to learn. I'm eager to learn and I'm willing to help, equally eager to help. So please help me to help you. That's from me. With regards to the other part of the question that the person had was the fees with regards to returning residents, their loved ones, and their husband or wives. You it depends. Again, going back to the criteria, if the child is under 18, then there would not be a fee attached. If they're over 18, then there will be an adult. So they may not be able to come back with a returning resident applicant unless they live in the house with a person for over 2 years and show that they're part of the household. So there are different things that will have to be considered before it can be applied. Somebody said they love my honesty. Thank you very much. That's the only thing you're going to get from me. I'm not, like Carlton said, no point we not telling you what you're up against because we're setting you up for failure. And unfortunately, that's exactly what is happening or has been happening. Hence, there's been so little take up to the schemes. People think, well, oh, it's going to be easy. Let's just put in an application and not really consider what the application is actually saying, reading between the lines, the degree of the evidence that you need to support your applications. And you're just getting rejected. And one of the things that I've noticed over the years, because I've been working on Windrush applications since 2019, before the compensation scheme was launched, when Martin Ford was commissioned to do it. When he did it, I was asked to read said applications by the organization I was with. So I read everything, the guidance and the compensation schemes, the status schemes, and I pointed out things that really didn't make sense, put simply. For example, like how the scheme was limited to 3 years, but asbestos claims, asbestos is a disease which manifests itself like maybe 20, 30 years after you've been exposed. But then you can still go to court and make a claim for asbestos, but you can't for something that's been around for over 75 years, a hostile environment, or even longer. 3 years, you're going to get people to come forward who don't even understand the legal jargons and the complicated and convoluted way the schemes were written and worded. Really, how is that supposed? Are you really trying to right the wrongs? So these things were questioned, and I'm here. I'm an advocate for people like yourselves. Anyway, so that was extended, and now there's no deadline. But these things don't get advertised. They just make the changes, and sometimes we don't even know about the changes. Going back to case law, we won't know a case is going through the court unless it's advertised or unless somebody knows somebody who's going through it. So we do not know when things are happening. So please do share with us. We can't know everything, but with your help, we can know enough that we can help make a difference and influence the changes we want to see. But going back to the fees, I think I've just answered that. And one of the other things I want to say, Garrick, in the form the link that I put in the chat earlier, it says if applicants who want to return, they don't want to come and live in the UK, but they just want to come back as visitors periodically. It says that if applicants qualify as a returning resident, but state on the application that they only want to visit the UK, the Windrush Help Team will consider whether they also meet the requirements for a visit visa. Not that you're going to get it, they're going to consider whether you meet the requirements for a visit visa under the immigration rules. And if so, they will be granted a 10-year multiple entry visa, which means you could only come for about 6 months. A 10-year multiple entry visa, which will allow them to visit the UK for up to 6 months at a time within the 10-year period. So it's not, again, easy compared to the Hong Kong scheme, which they have in place, the Ukrainian scheme, and the EU schemes. They are more favorable than the Windrush schemes.
Yeah.
I hand over to you, Garrick.
Yeah, thanks for that, Tanika. And it's good for the audience to know that following Brexit, people from the EU was able to use the Windrush scheme to apply for their status. And if you look at the data that's been produced as how many people have made application to the scheme, you will see that EU have exceeded the highest number, have exceeded application. If you look at Jamaican who have actually applied to the scheme, just over 3,000, and EU have exceeded for nearly 5,000 applicants. That does tell you something about what's happening. And it has been said publicly on LBC and other places that the Ukrainian scheme and the Hong Kong scheme clearly shows a discrimination against Black and brown people. There's no doubt about that. That is evident. That is the case. I'm just going to read a couple of things because, Tanika, you've led me nicely into visa. Individual who are currently overseas able to apply. And I'm going to just mention some of the different type of visa that you can apply to. So returning resident visa is 1. Standard visitor visa is 2. Marriage visitors visa is 3. Short-term study visa is 4. Student visa is 5. Work visa is 6. And family visa is 7. They're all listed under the Windrush scheme, individual or outside of the UK from overseas. And just me read a paragraph just below, which says, you can apply to the Windrush scheme from abroad if you're a Commonwealth citizen who settled in the UK before the 1st of January 1973. We keep emphasizing that. If you have the right of abode, you can apply for documentation confirming this. If you used to be settled here, but you have left the UK for more than 2 years, you can apply for a returning resident visa to live in the UK. If you have strong ongoing ties to the UK, family, etc., this will mean you have indefinite leave to remain when you arrive in the UK. So that's under the Windrush scheme, are individual currently overseas able to apply. So, and then finally, next paragraph says, data published on the 27th of May, 2021 show that we have granted documentation to over 237 overseas applicants to the Windrush scheme. If you're not eligible to apply for the Windrush scheme, you can still be able to apply for a visa to come to the UK. And that is why I mentioned the different visa listed. So I hope that is helpful. And again, this information is available to the public. It is guidance, you know, at the Home Office published, applying to Windrush scheme from overseas. So the guidance is there for everyone to read and share and understand. Okay, Tanika.
Yes, I wanted to come in here, Gark. So some KM asked, what's the difference to indefinite leave to enter compared to what, Kim? Is it indefinite leave to remain? So indefinite leave to enter would be similar to like them giving you a 10 years visa. You can enter as multiple times or many times as you want, compared to indefinite leave to remain, that you could come here and you can stay as long as you want, i.e. more than 6 months, like what a visa would grant you, depending on the type of visa you have. If you have a spouse visa or a work visa or student visa, then that's a longer period that you can stay. Indefinite leave to remain, meaning that you can stay here and work. With indefinite leave to remain also, it means that you're not restricted to certain things like benefits maybe, but you have to check and see exactly what you're entitled to do, not to do with each visa.
Yeah.
Because the
Yeah.
rules keep changing. I just read something on here on the same link that I sent to you, and it says along the lines that the Home Office will consider each application based on the law and policies as the data is received. However, if there's a discrepancy between law and the policies, they will use this document or the policy here to assess the application. So they won't necessarily go by the legislation that's active at the time. So please be aware of that. Again, going back to the Home Office has discretion. Maybe that's a discretionary aspect that they're applying to choose their policy over what legislation states. Where that lends itself is that we can take them to court and say, well, the law supersedes. No one is above the law, the rule of law.
Yeah.
That's the rule of law. Garrick, the reason why I also wanted to come in here is that I wanted to remind people who are eligible to the scheme, people, i.e., countries, and the Commonwealth citizens, what it means. So I'm looking at a document, the Home Office's document, and it reads Commonwealth citizens means citizens of the following. So these countries, people who have been affected or think they may have been affected, please do get in contact with us. First countries, Anguilla, Antigua and Bermuda, Australia, Bangladesh, Barbados, Belize, Bermuda, Botswana, British Antarctic Territory, British Indian Ocean Territory, Brunei, Canada, Cayman Islands, Cyprus, excluding the sovereign bases areas, which people in Cyprus will know what that means. There are 3 different areas. I think Eric, I'm not going to guess the names of them.
Yeah.
Dominica, Falkland Islands, Fiji, Ghana, Gibraltar, Grenada, Guyana, Hong Kong, India, Jamaica, Kenya, Kiribati, forgive my pronunciation of any country's names, Lesotho,
Yeah.
Malawi, Malaysia, Maldives, Malta, Mauritius, Montserrat, Namibia,
Namibia. Yeah.
thank you, Nauru, Nauru, New Zealand, Nigeria, Pakistan, Papua New Guinea, Pitcairn, Henderson, Duce, and Ono Islands, St. Helena, Ascension, and Tristan da Cunha, St. Lucia, Samoa, Seychelles, Sierra Leone, Singapore, Solomon Islands, South Africa, South Georgia and South Sandwich Islands, Sri Lanka, St. Kitts and Nevis, St. Vincent and the Grenadines, Swaziland, Tanzania, the Bahamas, the Gambia, Tonga, Trinidad and Tobago, Turks and Caicos Islands, Tuvalu, Uganda, Vanuatu, Virgin Islands, Zambia, and Zimbabwe. In addition, the following people are included: citizens of the United Kingdom and colonies by virtue of a connection to a country or territory on the above list, British subjects without citizenship under the law on 1st of January 1973. Thanks, Garrett.
Yeah. Now that's really important for us to get the sense of, when we keep saying that Windrush is global, and we're not even thinking about the countries, and we've just been listed those countries, and a lot of those countries citizens don't even know that is the case. They haven't got that information. They don't know. So we have to keep on promoting this and let people know how wide the Windrush scheme is. The other thing, while you was reading those names, Tanika, I was thinking that, you know, we should be putting those names out with all our information that we put out.
Agreed.
Yeah, so that people can immediately see, oh, that country is listed. I think that will help us. So we're going to do that, both in law and also with Justice for Windrush Generation. Because the more
Garrett, can I ask a
information,
question there, actually? So anybody in the audience, can you please give us advice or comments on things that we could do that you think will help you and others? Because we've done what we thought so far may be of service or of use to you guys, but we don't, again, know everything. So please tell us if you, like, I think Joy, I agree that that's a good idea. Thank you very much. If there's anything else that you think could help for us to reach people, to share knowledge, education, and or simply have a discussion. Challenge us. Again, we do not know everything. So if we can get Roland on the line, he will be challenging me, for example. Create a TikTok. Thank you. I'm gonna ask Garrick to create a TikTok and put his lovely, handsome face on there. That's all. That's all, Garrick's. But thank you for the advice and suggestion. Please do keep them coming in.
And that's what we want. We want to reach as far as we can, and whatever medium that we need to use, then we need to, you know, to push it out there. The information need to go as far as and wide as possible. The other thing that we want to get from you coming on the call, we want to look at how we collect information, because we're trying to build some data, some research data. And what we're thinking, that everyone that come on the call, that we have an email address for, we can actually send a questionnaire out to you, and you know, for you to feed back onto the questionnaire, and let's see if we can, you know, collect some information. One of the difficulty with the Windrush is that we haven't got enough data out there about, you know, what has happened to people. And I know it's difficult for people to keep on telling their stories, and some of the stories are very painful. But at the moment, there is some research being done looking at trauma around mental health, trying to collect some information on that. For Justice for Windrush Generation, we've been focusing on collecting data around homelessness, people that have had, you know, issues with homelessness. They've lost their house, they lost their mortgage, and so, you know, you know, some people don't even want to talk about it because they're so embarrassed about the situation. They don't want to tell anybody about it. But again, we need information, you know, so we can say, you know, roughly, you know, how many people are in that situation. So it is important for us to try and collate as much information as possible, that when we're making these cases and we're pushing the, you know, pushing the MPs, and we're in Parliament every 2 months. The next one is the 14th of November, and it's good for us to, you know, to have some data that we can push and say, well, you know, this is what has been happening to our people, you know, rather than the anecdotal stuff that we can say, but we just need to substantiate a little bit more with some evidence. So, you know, please feel free.
Garrett, if I can remind you to please speak about our event that we're having next month.
Yes, sure.
In addition to the data that we're looking to get, because I am also a PhD candidate. I'm in my second year of my PhD, along with training to be a barrister. And I'm keen on research. If you want evidence or influence change, you need to have evidence, or in this case, data to back it up or to support your arguments both as a lawyer and as a researcher. So we need to show the effects of the hostile environment and everything else that has been impressed on us as a people, and the changes that we want to see. So I personally hope, and I know I have Garrick's support, and hopefully other people, if you guys can come aboard, your support to create and build that data. I have other researchers willing to work with us, who are working with us actually, and with different skills and expertise, and we're going to go at it from a research perspective, because policymakers and people in parliament, they appreciate and respect the research. What does the people have to say? This is your chance to have your say, but
Yeah.
do it in a way that they understand, because you can't go to the dance and not know what the rules are or play the game. Excuse upon an analogy. So Gareth, if you could please speak about our event and the aim of that.
Yeah.
And also Rafa has his hand up.
Yes, I see that. Yeah.
Okay.
And so, as I said, two important days for your diary. The 14th of November is a face-to-face and hybrid event in the House of Commons. It's the last event for 2023. So after the 14th of November, we won't be in Parliament until January 2024. So we do it every 2 months. And what we're doing there is bringing the issues to Parliament and MPs, so that we can push for improvement of the Windrush scheme. As we keep saying, that we're not happy with the scheme, but we're having to work with what we have. So we keep pushing for changes, and we will continue to do that through the parliamentary lobby and rallies. So that's the 14th of November. It is a Tuesday, and you can find that information on the Eventbrite platform, to which all our events are promoted on the Eventbrite platform. So Justice for Windrush Generation House of Commons is on the Eventbrite platform. The second date for your diary is the 11th of November. On the 11th of November is an in-person event in Liverpool, in Toxteth, targeting Africans. And we have particular reason to target Africans, because Africans do not understand the Windrush compensation scheme, and we're challenging this myth that it's a Caribbean thing. So, the venue that we've chosen is a venue that is used by Africans, and the CEO of that venue is from Nigeria, and he's a chief, and he's from the Igbo tribe. So that event will take place in Liverpool on the 11th of November, starting at 11 o'clock till 4 o'clock in the afternoon. It will be on the Zoom platform as well, so you can join on Zoom. But in person, we'll have space to be able to engage with people and conduct some survey, collecting some survey from individual cases. Tanika doesn't know this yet, but that event will be filmed. I've got a filmmaker coming to record that. So it will be recorded live. So that's 2 dates for your diary. We in the last final stage of our new website. So Law does have a website. It hasn't gone live yet. We're just doing some tweeting to the website, and that will go live very soon. And it will be Liverpool Advocates for Windrush. That would be the website. So you can find information on that site, the same ways you can find information on Justice for Windrush Generations.co.uk. 2 sites that you need to a regular visit, that will keep you up to date with what's going on in terms of activity, etc. And also we have the contact email address and phone number on the site, WhatsApp number, so you can reach out directly to us and we will respond to you. So please make a note of those 2 dates. The Sunday chat that is delivered twice a month by Justice for Windrush Generation, that is the second Sunday and the last Sunday of each month, the second and last Sunday of each month. And again, you can find all this information on the Eventbrite platform. With Justice for Windrush Generation event, everything is on the Eventbrite platform. So I
Thank
hope
you for
that's
that, Derek.
helpful.
Yes. Please, if you could go to Rafa, he's had his hand up for
Yes,
a while.
yes, going to
And
go
I
to
have
Rafa.
one more question from the 3 questions that came through originally.
That's okay.
So we go to Rafa first.
Yeah,
Hi,
that's fine.
yes, sorry. Just wanted to go back to the indefinite leave to enter and remain. So I just think it's my understanding that indefinite leave to enter and remain are exactly the same, which is permanent residency. The difference is that for people applying from outside of the jurisdiction, you have to get indefinite leave to enter. So
Right. That sort of makes sense, doesn't it, when you think about that?
yeah. So
And the remain means that you can stay in the UK for as long as, you know, whatever. Yeah.
right. So once you've entered, then your indefinite leave to enter becomes indefinite leave to remain.
Right. Okay. Well, we will actually accept that. And what Tanika and I will do, we're going to check this out with our legal team, and just you know, if anything changes, then we will certainly report back at our next session. But that's fine, Razi. Thanks for that. Let me just say, so we had some really good questions this afternoon, and one of the suggestions we were making, and maybe some people have missed, they came in a little later, is that it would be really helpful if we had the question at least 36 to 48 hours in advance. It will allow myself and Tanika to research the question and make sure we have all the answers. If we get the question in much shorter time, we're doing an injustice. So we're quickly trying to find the answer, and you know, we may need a little bit more research. When there is more information to be provided to that question, we will certainly either give you that directly from your inquiry. So if you did it by email, we will give you the email response. If you did it by WhatsApp and so forth, we'll give it to you by WhatsApp response.
Derek, we have another question from the 3O just before you finish off.
Okay.
I didn't know if you heard me before.
Yeah.
Thank
so you. You know, as I said, it's always more helpful if we had it in advance, because it, you know, preparation time is good. So we really give you the best response that we can, having more time to look at the question and find the answer. And it doesn't mean, you know, you cannot just have to stick to the question time. You know, if something has come out of a conversation and you want an answer, you can certainly contact us, you know, anytime, you know, for an answer. But just trying to streamline the way the session work, I think you know, advanced question is far more helpful. And we know that there will be questions that will come out of the conversation. So while we're talking, you might be thinking of a question, yeah, a subsidiary question. That's fine, no problem at all. We can do that. Now, Tanika, you just mentioned, did you say there was another question?
Yes, from the person who asked the questions, i.e., can successful overseas Windrush claimants apply for UK citizenship in the same aspect of Vanrel and Toomey?
Yeah.
And the other one with Mahabir. The third question to that is, and what about any overseas born children of that claimant who are now adults? So I think I've went some way to answer that question already, saying that if the child is children are over 18, they may not be able to come as a dependent on the returning residence visa with the returning resident claimant because they're adults. However, if they're, for example, the carer of said returning resident, or they live in the same house, they may be able to. I know the Hong Kong scheme allows for that. And that's one of the things we're trying to put forward as a recommendation to the Home Office to say, well, the discrepancies and disparities within those schemes that we mentioned before, i.e. the Ukraine, Hong Kong, and EU schemes, compared with the Windrush schemes is not fair, or why are they such vast discrepancies and differences when we're still dealing with returning residents or people coming here because you set up such policies that it can. I'll just leave that on that point. So I think I've went somewhere to answer that. If it's not sufficient, do feel free to message me. I will also be speaking with that person to get further information to see how I can help them with their case. As Garrick was saying, I'll second that. If anybody has any other questions, we will try to, because we've started late, we will go over a bit later today. If you need to go, we understand that. That is not a problem, but do feel free if you have any subsidiary questions, please do feel free to come on the mic, send a message in the chat alternatively, and we will aspire to answer it now. If we can't, we'll come back to you in the next meeting, which is 2 weeks from now.
Yeah.
Every other Sunday, the first and third Sundays. And 2 weeks Sunday from now is the 29th of October.
Yeah. We think that date clashes, Tanika. I think
It shouldn't.
Yeah,
It
I don't
shouldn't
know
clash
why, but
because
by the
next
message
week.
it clashes. We'll double check that.
Yes, but even so, we will be having this Q&A next on Sunday the 29th, because next week will be the Windrush Justice, which is the 22nd.
Yes.
And then it should be the following Sunday, which will be the 5th
Yeah.
of
Yeah.
the 5th of November, sorry. So it should not be any clash based on the point
that's
I
fine.
just looked at.
That's fine.
Yes, but if you have any questions, please feel free to pull them through now. Thank you.
Yeah. Let me just refer to guidance, and I'm just going to read a couple of paragraphs. I think it's quite important to re-emphasize this. And it's on the returning to the UK if you had indefinite leave to remain section. You may be able to come to live permanently in the UK as a returning resident if you previously settled there. What you need to do depends on how long you were away, and we talked about the 2 year before. You cannot apply for a returning resident visa if you lose your settled status under the EU resettlement scheme. Check how long you can stay outside the UK if you have settled status. And then the next couple of paragraphs, if you're away from the UK for more than 2 years, you still have your indefinite leave to remain if you were away for less than 2 years. Notice the point? You can re-enter the UK as long as you had indefinite leave to remain when you last left, right? Let me read that again. You can re-enter the UK as long as you have indefinite leave to remain in the UK when you last left. You did not receive financial support from the Home Office to leave the UK. When you travel to the UK, show the stamp or biometric resident permit that you originally gave you permission to settle there. If it is an old passport, carry both your old passport and your new passport when you travel. I hope that is helpful. And if you lost the stamp in your original passport or residence permit, if you do not have your original stamp or resident permit, you may not be able to enter the UK. And then it talks about replacement, etc., etc. So again, that information is public information on the return to the UK if you had indefinite leave to remain. So just finally, Tanika, so I've got Rizzy got a hand there?
Yes, but before Rafa comes in, I want to correct myself. Roland has pointed out that October month has 5 Sundays.
Oh,
Our program is the first and third Sunday in a month that has 4 Sundays, not 5. So today is the third Sunday. The 1st of October was the first Sunday. Our next event then is on the 5th of November, not the 29th of October.
Yeah.
Hence the clash that Roland had mentioned.
That's right. He said, yes. Now it makes
So
sense.
I do apologize, and I stand
Yeah.
corrected that because October has 5 Sundays this year, and our program is only the first and third Sundays of every month, which normally there are 4 weeks or 4 Sundays in a month. Our next program will be the 5th of November, Sunday, the 5th of November, 3 to 5 p.m. UK time, 10 to 12 America and Caribbean time. Thank you.
Yeah, that's great. I'm glad we corrected that, because I did read that from Roland that it date clashes. Okay, thanks very much for that. So can I just take the final question now, please?
Sorry. I just want I don't know if you all have any information on Section 1.5 of the Immigration Act, which used to give Commonwealth citizens the ability to enter up until August 30th, 1988. Now, I think it was Home Office in 2006 said that the Commonwealth citizens were exempt from the 2-year rule. And that guidance recently changed, maybe in 2022. They realized that was an error, so that actually Commonwealth citizens weren't actually exempt from the 2-year rule. But they only recognized, so between 2006 and 2022, the Home Office was of the belief that the Commonwealth citizens were exempt from the 2-year rule. So I was just wondering if you all had any information around that, and how, if your people have come to you that were negatively or positively impacted by that rule. And there was an explanation, I think, by Vicky Vilcroft that's online, and there's a letter that the Home Office, Dame Diana Johnson, had requested clarification on the situation. So I just don't know if you all have any information on that.
Okay, thanks for that. Tanika.
No, we don't. And
I don't have anything, but we would need to check this out, you see, because you referred to Section 1.5 of which act? What year?
1973, I believe he's
73. Okay.
But we do have a
71
enacted 73. Yes. We do have a immigration barrister, I believe, looking into this matter already. And once we get an answer, we're going to get back to you with that. And also
this one is slightly different from my matter, but it's just, it's just good information, I think, for the people.
Definitely. But that may be something that will come up. She will come across, bearing in mind, in addition to the information I'd already sent you, Rafer, from what one solicitor has been able to find based on your situation. And when we answer questions, we just don't answer based on the specific scenario that you give. We give, well, if this was the case, then that would be. So we go a bit further. So hence I'm saying that will come out with the answer, or may likely come out, I should say, with the answer to what you asked. But I also will look into that, because I'm not aware of it. Again, unless you listening for something specific or tuning in or researching something specific, you would not know everything that's happening. Equally with the suggestion that Rohan has given in the chat. Thank you for your suggestions. We did ask to do what else we can do, but not everything we will be able to do. So that is very specific, and it seems as though you want us to do that. But unfortunately, that requires more than we can do at the moment. That's statistics and data that you're asking us to go find. It may give us some information, but some of the things, when I read it, it lent itself to slavery, colonialism, reparations, chattel slavery. So all of that stemmed from that. I'm involved with that too. So that's what that led me to. So what you're saying has, it links itself to different issues, but this is not the platform necessarily for us to go down the road that you've suggested, Rohan. But thank you again for your suggestion. Please feel free to keep sending them forward. If we can take it on board, we will. If not, I will like I'm saying now, that we will not be able to, at least not at this moment. But thank you.
No, that's fine. I'm glad you mentioned the fact that because at the moment there is the big reparation debate, global debate going on, and you know, we're part of a bigger conversation, and we're feeding information into that big debate. Um, there are people who just focusing on that issue around reparation, um, and so, you know, whatever we can feed into that process, we will. We won't take it on ourselves, but we have those linked across into CARICOM and other parties. So that's good. So we've reached the end of our session. It's our 2-hour questions. Been very interesting questions. I hope that we will continue to have questions like these, because it does help us to sort of focus on, you know, what are some of the issues affecting individual. And that's exactly why we set this up, because we wanted to know what are some of those barriers and how we can help you to overcome those, and in make your application process much easier. So thank you very much for your contribution. We will see you again, as Tanika mentioned. It will be November 5th of November will be the next session. And I've mentioned the dates for the Liverpool event, 11th of November. And also I've mentioned the Rally of Parliament on the 14th of November. Both of these events are face-to-face and hybrid, so you'll be able to join the either way, whichever is more convenient for you. So that's great. Thank you very much, and I hope you enjoy the rest of your evening.
Gareth, 1 second. I think Roland may have. Roland, can you come online now? He just joined, or
yeah, was his audio? Can we hear Roland now? Was there a problem with the audio before?
yes, I even tried making him host at one point, but he just rejoined. I think he may have rejoined from a different device.
Right.
Roland, can you hear us?
Thank you, Joy.
He just joined, but
Yeah,
I guess
I can see him, but the audio don't seem to be moving, so I don't know. It's still got muted. It's still got muted, and I can't.
Yes, he's now on 2 devices.
Oh, I see.
So maybe he's trying to access from the second device.
Yeah, I can't interfere with it because I try to unmute, but nothing happens.
Yes, same. So I've tried. Oh, he's trying again.
Yeah.
Okay. Roland is one of our colleagues. He's also Windrush Justice, part of the Windrush Justice group, and also a Windrush victim himself. The reason why we're keen on getting him to come on the mic is because he does have some valid points that he normally makes, and contributions, and also information that may help.
And Roland gets a lot of inquiry. And sorry, Tanika, Roland get a lot of overseas inquiries. So, you know, he's picking up some of the issues that people are experiencing. And, you know, I think the audio is coming through in a moment.
Yes, it says joining still. I've admitted, so apologies for the delay, but also because we started late, we are, you know, prepared to go over, because we did.
We can go until 10 past.
Yes, we did start late, unfortunately. So we're just trying to give Roland an opportunity to join with audio, but it doesn't seem. Roland? Okay, so what maybe I may be able to do, I can probably call him on my phone and he can speak through my device. So Roland, have you heard me say that? I'm calling you. Hi, can you hear me, Roland?
Joining from another device.
Okay, but it's not coming through. Yes. So yes. So Gary, can you hear him?
I can hear. Yeah.
Okay, good. So you can speak now, Roland. He can hear. Everybody can hear you.
Can you hear me, Gary?
Yes, I can. Go ahead, please.
Yeah. What I want you to pick up on is what was mentioned. Good afternoon, everyone. Is what was mentioned earlier on. The hostile environment.
Roland, excuse me. Sorry, it says your audio is on the computer, your second device. Do you want to try speaking through that? Your audio button just came up.
Can you hear me?
Not. I can hear you through my phone, but through the audio on your computer or device which you joined with.
Device. Gary, can you hear me?
I can hear you. Yes.
Right. Okay. Yes. The point I'm trying to make is the Home Office, and Theresa May said hostile environment started in 2007, 2012. The hostile environment is a generic name that is used by the Home Office in reference to when these laws came out 2012 to 2014. But in terms of the hostility towards the Windrush generation, that started long before the 2000s. And we should not be referring to the hostile environment started in, as Theresa May is saying, when she said it started, because there are good reasons why I'm saying that. If we accept it as such, the Home Office will use that as an excuse to narrow the scope of the scheme. Just like they're trying to do with where it says if you came from any country before the 1st of January 1989, you can apply to the scheme. And the approach that they're taking at the moment is except the Commonwealth country. In that particular part of the guidance note where it says if it came from any Commonwealth country, it does not, not any Commonwealth country, if it came from any country, it does not say except Commonwealth country. But the approach the Home Office is taking is as if it says if you came from any country before 1989 except Commonwealth country, then you can apply to the scheme. That's not the case. It says from any country. That means that particular reference does not exclude Commonwealth country. So I'm just saying that we've got to be mindful of how we not just Gary and Tanika. What we're saying. I met the same thing when I went to Liverpool at a French meeting. I think a young professor there said the hostile environment started in 2012. That's totally incorrect. The hostility towards the Windrush generation started well before that. If they're gonna put up whatever barriers and give whatever excuse they want to give, say they've got to provide additional evidence and so on, we must not pander into that through our utterances. Because for certain, at some point, it will be used to narrow the scope of this. I just wanted to make that clear.
Yeah, thanks for that. Yeah. And in many ways, you're right, Roland, because we don't want to encourage the Home Office to change their policy. This is something we'll take back to the independent advisor, and we will push this because we have regular session with the independent advisor. We'll make sure that we push this, not to restrict the Home Office into this situation where they're accepting dates and which are going to disadvantage the claimant. So we will pick that up, Roland, with our next independent advisors meeting. And of course, this is the opportunity we have of bringing some of these issues to the independent advisor, where we have some real concern about Home Office practice and policy. So we have got that, that linkages to effect change. So we will use all our powers that we can to make sure we are representing and pushing, get the best outcome for our Windrush generation and descendant. So thank you very much for that. It is useful for us to do that, because when you think about it, when the Windrush compensation scheme started, if it wasn't for the effort of individual pushing, challenging, we wouldn't have got any of the improvement to the scheme. And we have had improvement to the scheme, even though those improvement and changes, have been small, and some has been, pretty major in terms of, the compensation and how we started with a limited amount of money, and that was expanded beyond the 10,000 and the 20,000, the 50,000, etc. So it does help us keep pushing and making sure we are pushing for better outcomes and changes. And that's one of the reasons why we do Parliament. We're trying to get changes to the scheme. The scheme doesn't need to be in the Home Office, but clearly it's still there. We're trying to get changes. And of course, the days of this current government is numbered. There will be an election in 2024. So we're looking for a new administration that we can push better outcome for Windrush. So thank you very much for your attendance and for the question that you've posed. It's been very interesting. We're going to say till next time. And Tanika, you and I are going to stay on because we need to have a conversation.
Yes. I'm just going to put our email in the chat if anybody needs to contact us, and our phone number. Actually, I'll put a flyer if I can.
Yeah, if you can put a
in
flyer
the chat for our event coming up in
11th of November.
Yes, and on the flyers also it has let me see. It has copy image. It has our phone numbers. If you need to get in contact with us, please feel free to do so. Oh no, I can't paste it or send it. Roland, you're really good at this. Can you please post the flyers for us? Both of them? Because I'm not sure how to do it. I'm not that tech savvy. Sorry, guys. But if not, we will aspire to get it out to everyone.
Yeah.
One way or another. So again, thank you very much. Yeah, I'm unable to post it on here, but we will send it out and circulate. Yes, Garrett, I will be staying on.
That'll be fine. Thank you.
Thank you again for coming, everyone, and hope you have a blessed week ahead.
Excellent. Okay. Bye-bye for now.
Thank you. Stop recording.
Thank you.